And greetings. Welcome to Judgments, Consent Judgments from American Jurisprudence. We're going to leave off, we're going to take over from where we left off last time, and we were going through the various types of judgments, and now we're going to get into consent judgments, which is a whole nother ball of wax. So let's get into it, starting with Section 173, Consent Judgments Generally. And before we get started, just remind everyone this is broadcast strictly for entertainment and educational purposes, not to be used for professional, personal, legal, lawful, financial, or tax purposes at all. Don't do this at home. All right, let's continue. A consent decree is primarily a means by which parties settle their disputes without having to bear the financial and other costs of litigating. It normally represents a compromise between the parties who have waived their right to litigation. See, is a consent decree. And the title is Consent Judgments Generally. So we're starting with the decree, which typically applies to equity. Courts have the general power of entering judgments by consent of the parties for the purpose of executing a compromise and settlement of an action. A consent judgment is one that is entered by stipulation of both the party against whom judgment is entered and the party in whose favor judgment is entered. It may settle all issues or reserve an issue or claim, but it must precisely state what issues or claims are being reserved. A consent decree is not simply a contract entered between private parties seeking to effectuate parochial concerns, but it is a judicial act. An offer of judgment under the federal rules and state counterparts, if accepted, results in a consent judgment. Offers of the compromise made before suit is filed do not fall within the rule. So an offer of judgment under federal rules and state counterparts, if accepted, an offer of judgment, if accepted, results in a consent judgment. So if you're offered a judgment under federal rules and state counterparts and you accept it, it results in a consent judgment. Offers of compromise made before suit is filed do not fall within the rules. So the compromise must be made after the suit is filed. That's footnotes 9, 10, and 11. Let's take a quick look at those. Federal Rules of Civil Procedure. Okay. This one here is 1983 and 1980 and 1994. All right. It takes us to the end of this section here, except we have a footnote here. However, all right, it was stated that although purporting to be a judgment by consent is not, strictly speaking, the act of a court, but rather the act of the parties to the suit. However, so that was on footnote 8, and I think that was, judicial act. Consent decree is not simply a contract, but it is a judicial act. It's not there seeking to effectuate parochial concerns. However, it was stated, although purporting to be a judgment by consent is not, strictly speaking, all this language is say it's not the act of a court, rather the act of the parties. It's an act of the parties, but it is a judicial act ultimately too, under this case here. And that's a footnote to that case. Or one that came in Nebraska afterwards. Oops. Oh, Lord. Give me a moment here. Oh, lost it one more time. Just a second here. All right, there we go. And zoom back in here. All right. And that takes us on to section 174, consent judgment distinguished from judgment on the merits. So let's double check on the chat here, make sure everyone is in. Please give me a heads up if everyone can hear everything all right. and that we're coming through clear in the YouTube land, and then we shall continue. On with section 174. Consent judgment distinguished from judgment on the merits. A consent judgment is different in nature from a judgment rendered on the merits because it is primarily the act of the parties rather than the considered judgment of the court. So once again, it's different from a judgment rendered on merits because it's primarily acts of parties rather than the considered judgment of the court. They consider the facts. It's the acts of the parties rather than the judgment of the court to consider the facts. However, a consent judgment is still a judgment and an order of court. Its only distinction is that it is a judgment that the court enters at the request of the parties. No pleadings are required to support an agreed or negotiated judgment. Consequently, a judgment by consent is distinct from a judgment rendered by the court after trial. Consent excuses error and ends all contention or controversy between the parties within the scope of the judgment. Generally, no appeal will lie from a consent judgment. You say plea agreement. Caution. A few cases have taken the view that a consent judgment may be reviewed on appeal, although the scope of review is extremely limited and subject to exceptions, such as where the public interest is affected by the judgment, or where there is a claim of lack of actual consent or lack of subject matter jurisdiction at any time. If the party gave consent merely to facilitate an appeal following adverse determination of a critical issue, the party might not lose his or her right to be heard on appeal. So, it's back to the intent. If it gave consent merely to facilitate an appeal, then that might be one where, because of the adverse determination, you won't necessarily lose a right to be heard on appeal. So, nice distinction here in the caution box. All right, we're on to section 175, the powers and limitations of court, rendering consent judgment. All right, excellent. Thank you, Bill Thomas. And let's continue on. So now the powers and limitations of court, rendering the consent judgment. So remember, it's a judicial act. So let's see here. A judgment by consent, in order to be valid, must be within the jurisdiction of the court. In addition, the power of the court to render a judgment by consent is dependent on the existence of the consent of the parties at the time the agreement receives the sanction of the court, or is rendered and promulgated as a judgment. So this means that, again, it has to be in the right jurisdiction, regardless if the parties agree to a consent judgment here. And in addition, the power of the court to render is dependent on the existence at the time the agreement receives sanction of the court. So it has to be done, again, this is like a during trial thing, or is rendered and promulgated as a judgment. So this is after, the case has basically had its standing. Due to the unique hybrid nature of consent decrees, a court's role in determining whether to approve or deny a proposed consent decree is somewhat limited. Typically, a court reviews a proposed consent decree to determine whether it is fair, adequate, and reasonable, and to ensure that it does not violate any existing law. So typically a court reviews a proposed consent decree. Now, being it typically does, that doesn't mean that they're necessarily going to do that. So, word to the wise, to determine whether it is fair, adequate, and reasonable, and to ensure it does not violate any existing law. Good luck. Absent fraud or lack of consent, a trial court must approve or consent to an agreed judgment submitted by the parties. Okay, so the trial court must approve or consent to a consent judgment. Observation. Where the parties freely negotiate and enter into a consent order or judgment, there is no reason why they cannot bind themselves to the jurisdiction of a forum for the purpose of future litigation. Thus, a court concluded that an agreed order could act as a valid consent to personal jurisdiction, and a waiver of the requirements usually necessary to invoke that jurisdiction. Interesting observation there. The court has the power to issue orders necessary to protect the integrity of the stipulated judgments, but it may not enlarge or lessen the scope of the judgment. When the parties, plaintiffs, and defendants stipulate the findings of fact and the conclusions of law and hand these stipulations to the judge in open court, the court is not called upon to perform a judicial act. The writing is, in fact, a consent finding in judgment, and the duty of the court is ministerial, to have the writing entered as agreed upon. If there is a lack of conformity between the stipulation and the judgment, an appeal may be properly taken from the refusal of the court to grant a motion to correct the judgment. So there's another grounds for appeal there within a consent judgment. If there's a lack of conformity between the actual agreement and the judgment. Observation. The enforcement by a federal court of states' consent decree obligations under a federal statute does not violate the 11th Amendment, even if violations of the decree do not constitute violations of the federal statute. Although the decree includes obligations not required under federal law, it is enforceable as a federal court order springing from a federal dispute that furthers the objectives of federal law. And that's from footnote 10. And that's Frew versus Hawkins, 2004. All right. And I don't see any other things here as far as the necessity of consent. See section 177, which we should be at shortly. And we're on to section 176, the nature of consent judgment. Remember, we're focusing here on the nature and the effects of judgments. So the nature of a consent judgment is critical for our understanding. Consent decrees have attributes both of contracts and of judicial decrees. Because of this dual character, consent decrees may be treated as contracts for some purposes, but not for others. Consequently, a consent judgment is subject to many of the rules relating to the interpretation and enforcement of contracts, as well as those governing the form, entry, and effect of judgments. Consent decrees closely resemble contracts because their terms are arrived at through mutual agreements of the parties. Even though a consent judgment receives a court's imprimatur, the judgment is, in essence, a contract between the parties to the litigation from which it is derived. Consent decrees do not arise from a judicial determination of the rights of the parties or the merits of the case. And some courts hold that a consent decree does not purport to represent the judgment of the court, but is merely a recital of an agreement. A valid offer of judgment, when accepted, is a contract, but it is not treated as a mere contract. The essence of the judgment is that the parties to the litigation have voluntarily entered into an agreement, setting their dispute or disputes at rest, and that, upon this agreement, the court has entered judgment conforming the terms of the agreement. Beautiful words there. That really sums it up tight. But there is a caution. An agreement of the parties not reduced to a court order does not constitute an adjudication of a pending claim. So make sure it's reduced to that court order, the agreement. It must be reduced to a court order. Caution. Pro tip there for you all paying attention. A consent decree is a contract which has been given judicial sanction, and as such must be interpreted in accordance with the general principles governing the interpretation of all contracts. All right, and now it brings us to section 177, the necessity of consent for consent judgments. So now we're going to get into the depths of the meanings here Consent may be defined as voluntary agreement by a person in possession or exercise of sufficient mental capacity to make an intelligent choice to do something proposed by another. Wow, let's read this again. Consent. A voluntary agreement by a person in possession or exercise of sufficient mental capacity to make an intelligent choice to do something proposed by another. The party's consent animates the legal force of a consent decree, so long as it is consistent with the law underlying the agreement. The decree's force comes from consent, not a resolution of the merits, and it creates obligations no broader than those to which the signatories have actual authority to give assent. Actual consent must exist, so the assent is from the individual signatory, right? Actual authority, and the consents between them must exist at the very moment the court undertakes to make the agreement of the judgment of the court. The court may not render judgment by consent where it is advised that one of the parties no longer consents to the judgment, or where there is no certainty about the existence of consent. A party must clearly and unmistakably give consent. Sufficient mental capacity to make an intelligent choice to do something proposed by another. But there is a caution. There is some authority that if a party to the cause wishes to contend that he or she did not in fact agree to an agreed judgment, the party must do so by direct attack upon the judgment and cannot do so in a collateral proceeding. The party must have a clear and certain understanding as to what is intended by the offer, or the court must not enter the judgment. So that's getting to our elements of a contract. With full disclosure there. And a practice tip. Where consent judgment is entered against two defendants, but only one defendant consented, the court must set aside the judgment as to both defendants, since a consent judgment, which may be set aside for cause, must be set aside in its entirety. So, two defendants, they got to cooperate for a consent judgment. And we have our cumulative supplement with the cases here. The federal court should determine supervision over a consent decree once a defendant comes into substantial compliance with the law, because indefinite federal court oversight of state institutions is disfavored. And that was, Peary versus City of Miami in 2020, the 11th Circuit. So that's very recent. So federal court should terminate supervision over consent decree once the defendant comes into substantial compliance with the law, because indefinite federal court oversight of state institutions is disfavored. So there must have been some problem with the City of Miami, because I guess that's the state institution that was having the federal oversight. I have to look into this case to find more, but it is recent, current, something to be aware of to see the changing landscape that affects our common law. As the authority of an attorney to consent to a judgment, see attorneys at law. See, standing alone, too indefinite to justify, was this notation approved as to form and substance. Standing alone is too indefinite to justify judgment as consent judgment. Okay, so there's probably details of those cases that would be very effective if they were concerning something of your nature of whatever you might be interested in. Let me center this a little bit better there. All right, there we go. And let's check on the chat. Consent agreements where there's a case before the court and there's the two parties have decided that rather than go through the costs of a lengthy litigation, they're just going to come up, they know where it's going to go, they've already laid out their discovery, and they decide, hey, you know what, let's just come up with this type of arrangement here, we'll get a judgment in this particular way, we'll just work it out amongst ourselves, and then you enter that motion to the court as a consent judgment, both parties agreed, the court agrees, or it should agree to that, and then it signs it off as a consent judgment, and then it functions as a judicial act going forward, not just a mere contract between those two parties that came to an agreement because of their dispute. So it's basically settling the dispute in private after you've already troubled the court to bring it in there. So I'm sure they're going to want their commensurate fees and everything else for the inconvenience of using up their courts and their docket, so to speak. So I believe that might be the best way I could explain it. But then again, this is just my opinion here, not to be taken as any kind of legal lawful advice. Not too sure if it'd be granting a conservatorship or something like that, but perhaps. But let's read on and see, because there's a lot to this. We're just getting started. Thanks for all you sticking along here. But we're going to get into some pretty important things about consent judgments everybody needs to be aware of, because this actually is more common than it seems. It's just under so many different shades here. So a party generally has a right to revoke consent at any time before the rendition of the judgment. So this is the necessity of consent, withdrawal of consent. Should have read the title here. So section 178, necessity of consent for consent judgment, withdrawal of consent. A party generally has a right to revoke consent at any time before the rendition of a judgment. For a valid consent order, the party's consent to the terms must still subsist at the time the court is called upon to sign the consent judgment. If a party repudiates the agreement by withdrawing consent before the entry of the judgment, the trial court is without power to sign the judgment. If one party withdraws its consent, and this fact is communicated to the court prior to the entry of the judgment, the court cannot proceed with its order. Once the trial court renders an agreed judgment, however, a party may not withdraw its consent if the trial court was unaware of any objection at the time of rendition. However, withdrawal of consent to a judgment has been found to be within the discretion of the court. And some courts have specifically disapproved the view that consent to a judgment may be withdrawn as of right any time prior to actual entry of judgment. So between the time the judgment is made and the time is entered by the clerk would be any time prior to the actual entry of judgment, where the parties have reached a valid contractual agreement as to the terms of a consent judgment, reduced it to writing, and signed the proposed judgment through their authorized agents or personally, and filed it with the court, and removed the case from the trial calendar, a judge may sign the consent judgment, even if one party has tried to rescind the contract to settle. Wow. As a general rule, a party may revoke its consent to a settlement agreement before the court renders judgment on the agreement. An agreed judgment may not be rendered thereafter, although the revoking party may be liable for breaching the settlement agreement. So yeah, don't be playing games in the court. Remember, this should have been done beforehand in the first place, so there's going to be a lot of scrutiny. And we're on to section 179, the necessity of legality of agreement underlying consent judgment. As we saw before, as long as the agreement doesn't violate any law, and the court was supposed to review this. But again, there is a necessity, so let's see whose responsibility that necessity lies with. Under a consent decree, a party can agree to greater obligations than could be achieved if the suit were to go to trial. Okay, so there it is, greater obligations. However, a consent decree cannot oblige a party to perform illegal conduct. The entry of a consent judgment is inappropriate. And the judgment itself is unenforceable when the agreement it encompasses or the relief it grants is illegal. You can let your imagination run wild there, or inconsistent with a law underlying the agreement. Before approving a consent decree, a court must be satisfied that it does not violate the United States and the state constitutions, statutes, or other relevant sources of law. An agreement underlying a consent decree may be held void as contrary to public policy if it is clearly contrary to what the Constitution, the statutes, or the decisions of the courts have declared to be the public policy, or if it is manifestly injurious to the public welfare. Nevertheless, a court is not barred from entering a consent decree merely because the decree provides broader relief than the court could have awarded after a trial, even where the court might lack authority under the governing statute to do so after a trial. So it's not barred from entering it merely because the decree provides a broader relief than could be awarded from the trial. So that's an interesting aspect too. Broader relief would be another reason for the consent decree as opposed to having it litigated. Stipulated judgment did not violate state statute requiring rate freeze. Wow. So interesting cases. These cases are probably real interesting reads. Of course, we don't have time for that tonight, so we're going to keep on with section 180, form of consent required for consent judgment. And let's hop over to the chat and see if there's anything else here. Refresh this. All right, and we look like we're moving along here. Appreciate everyone that's sticking along. I know it's this is some pretty dense stuff, but we got to get through the consent judgments because these are the type of judgments that end up actually resolving a lot of actions. And these are the kind of judgments that aren't necessarily going to set any kind of precedent, being that they don't usually go to appeal, except for rare exceptions that we read. So let's continue. According to some codes of civil procedure, a court may enter a judgment pursuant to the terms of a settlement if the parties stipulate orally in court or in writing to settle all or part of the case. Judicial supervision ensures that the intent of the parties when they verbalize a settlement is not vulnerable to conflicting interpretations. Explanatory clauses added by a judge when transcribing an oral agreement between the parties do not supplement the agreement, but merely explain the agreement. Explanatory clauses added by a judge when transcribing an oral agreement between the parties do not supplement the agreement, but merely explain it. So they don't add to it. They don't supply anything to the agreement. They merely explain it. So like in parentheses, other state rules provide that an agreement for judgment, like other agreements in a pending lawsuit, will ordinarily not be enforced unless it be in writing, signed, and filed with the papers as part of the record, or unless it be made in open court and entered of record. The entry of a judgment by consent implies that the terms and conditions have been agreed upon and consent given in open court or filed by stipulation. So very direct. That's why it has the force of a judicial act. Petition for discretionary review refused. Oh, okay. We're on to section 181. Consideration for consent judgment. And we're going to jump over the chat real quick here. We get Zach Tracy. Yeah, appreciate the content. Appreciate you showing up. I'm scaring people away telling them about how dense this information is, but it is. It moves pretty quickly, though. We'll be through this in no time, and I guarantee you're going to leave here with a deeper judgment than most of the, a deeper knowledge of judgment than most of the esquires out there. Usually they get pigeonholed into certain kinds of particular actions that they get involved in their day-to-day actions. Activities, I should say. This gives us a broader sense and more principled in law and in common law, and that's the purpose of this. So let's continue. We're on to consideration for consent judgment. So the consideration, a consent judgment needs no cause or consideration other than an adjustment of differences and a desire to set at rest all possibility of litigation. In exchange for the saving of cost and elimination of risk, the parties each give up something that they might have won had they proceeded with litigation. So there's our considerations here. Other than the adjustment of differences and a desire to set at rest all possibility of litigation. Saving of costs and elimination of risks. but they have to give up something they might have won had they proceeded with litigation. There you go. And we're on to section 182, consent judgment generally. Content of consent judgment generally. So the content, you can read this carefully. A consent decree must come within the general scope of the case made by the pleadings and further the objectives of the law upon which the complaint was based. A consent judgment generally should show on its face that it was entered by consent, but such a showing is not indispensable, and the fact may be established by other evidence. Attached items may be incorporated by reference into a stipulated judgment. So it should show on its face that it was a consent judgment somehow. All right, and we're moving on to section 183, terms of consent judgment, power of the court to modify an agreement. Ooh, this looks difficult here. Let's jump over to chat real quick. And Bill Thomas says he is following. Excellent. Let's keep going. A final judgment which is founded upon a settlement agreement reached by the parties must be in strict or literal compliance with that agreement. Again, it must conform to their agreement or contract. The terms of a stipulated judgment may not be extended beyond the agreement made unless the judgment includes a provision proposed by one party that works in favor of the other party, but that was not part of the stipulated agreement. The court cannot, however, surrender its duty to see that the judgment to be entered is just one, nor is the court to act as a mere puppet in the matter. Wow, it cannot surrender its duty to see that the judgment to be entered is a just one. It must make sure the judgment is a just one, and it can't be a mere puppet in the matter. That is amazing there. So let's see here. Part of the stipulated agreement that puts one favor a party provision proposed by one party that works in the favor of the other party, but that was not part of the stipulated agreement. Okay, but the court cannot, however, surrender its duty to see that the judgment to be entered is a just one. So that's an important aspect here. They're still going to have to render some elements of principles of law. And the parties may not agree to take action that conflicts with or violates the statute upon which the complaint was based. An appeal, okay, wow. Wow, so this is one way a judge could easily override a consent judgment or a motion for one. Say it violates the statute upon which the complaint was based. An appeal lies when the trial court, rather than entering the consent judgment proposed by the parties, enters another modified one. Okay, that's a whole other aspect there, but that gives us a pretty interesting perspective here. This statement right here in this case, mere puppet in the matter. Let's check out footnote 4. California State Auto Loan Association Insurance Bureau versus Superior Court. And that was 1990. Whew. Now that's going to be a complicated case. All right. In the case of an offer of judgment under the federal rules or state counterparts, the court has no discretion to alter or modify the offer of judgment as accepted by the offeree. The federal rule leaves no discretion in the district court to do anything but enter judgment once the offer has been accepted. Cases here, the trial courts act in entering judgment on stipulated settlement which did not conform to the terms of the settlement agreement between neighbors and landowners. It was not a clerical error correctable by a motion to correct a clerical mistake. Judgment was entered on the judgment the neighbors requested upon application to be entered, and the court intentionally adopted the erroneous language. See, form, judgment entered. Okay, it says an appeal. As to illegality of an agreement on which a consent decree is based. So we Already saw 179, and we're on section, let's see here. Did I miss anything here? Nope. All right, section 184, amount of consent judgment. Yeah, let's check out here. Yeah, we got to be aware, and that's one of the whole aspects of going over this. It's not that we have to agree with everything that we're reading here as far as certain case holdings. This is just the reality of the landscape, and it's from the perspective of common law in American jurisprudence. And in a way, it gives us a view to see how one of the greatest strengths of this nation is slowly becoming one of its weaknesses because of these liberal interpretations we're seeing. But I digress. Let's continue. All right, the rule requiring that a judgment for money specify with certainty the amount for which it was rendered applies to consent decrees. There is authority that a consent judgment pursuant to the federal rules of civil procedure dealing with offers of judgment for a specific sum, with no mention of pre-judgment interest, absent indication otherwise, must be deemed to include pre-judgment interest. Absent affirmative agreement of the parties to the contrary, the trial court retains jurisdiction after the filing of the compromise agreement to consider a statutory fee motion. Boy, they just gotta have their fingers in the pot. But that's that's one's mistake for taking a controversy that should have been solved in the private to the courts and eventually do it in the private anyways under their jurisdiction. Then you're going to be also stuck for whatever fees they can get out of you too. An agreement providing that judgment may be entered against a party if it fails to perform may be held enforceable even though the amount of the stipulated judgment is more than the amount the party would have paid if it had performed. All sums necessary for a daughter's college education is uncertain, and judgment is void and unenforceable. Ah, look at that language there, and that was 1974. Right, interpretation of consent judgment. Section 185, judgments by consent are construed and interpreted as contracts, to which the rules governing contract interpretation or construction apply. The entire judgment, all provisions considered, should read as a whole in the light of all the circumstances as well as the conduct of the parties and the pleadings and motions from which it emanates. The explicit language of the judgment is to be given great weight. Deference is to be paid to the plain meaning of the language of the judgment in the normal usage of the terms selected. So our observation here is a consent decree must be construed as it is written and not as it might have been written had the plaintiff established his or her factual claims and legal theories in litigation. So yeah, this definitely trumps any kind of legal theories or factual claims that might have been presented. Is a written contract and it's construed as such. All right, let's check over here on the chat. Hey, we got LA Spike in the house. Greetings and welcome. Yep, get out that clipboard. Yes, and please hit the like, y'all. All right, moving along here. And we're on to section 1. Oh, we're still on section 185. When interpreting a consent decree, words must be read in context, each of its provisions being interpreted together with its other provisions. Absent ambiguity in the terms of the consent judgment, the intent of the parties must be ascertained solely from the instrument itself, and extrinsic evidence will not be admitted. In determining whether a consent decree is ambiguous, the court may rely upon certain aids to construction, including circumstances surrounding the consent order's formation. Surrounding the formation of the consent order. Any technical meaning words used may have had to the parties, and any other documents expressly incorporated in the decree. So I think they don't want to see extortion surrounding the consent order's formation either. The interpretation of a stipulated judgment, like the interpretation of a contract, is usually a question of fact. A reasonable interpretation of a consent decree is one that comports with and furthers the purpose of the parties' agreement. The meaning of the consent judgment is to be gathered from the terms of the contract and the judgment should not extend beyond the clear import of the terms. Ambiguous contractual language is generally construed against the drafter of the language. So, sloppy language, if you wrote it, is going to be construed against you just to punish poor construction. The application to judgments of the rule of practical construction, that a construction adopted by the interested parties, especially if acquiesced in for a long time, will not be departed from the court except for strong reasons, has particular force where a judgment by consent is involved. So let's get to our cumulative supplements to digest some of that, because this will elucidate it better for us. Cases. A script for movie depicting musicians' experiences with rock band did not exceed authority that consent decree explicitly gave him, where consent order provided that each signatory had, here we go in quotes, the right to exploit his own respective life story in any manner or medium, including a motion picture, and to refer to band's name in order to describe and portray his experiences with bands, so long as the story did not purport to be the history of the band. Even though the movie depicted plane crash that killed 2 band members where musicians survived plane crash, and the movie focused on musicians' life experience. Can anyone guess what band we're talking about before I finish? And did not portray band's history. Per Newman, circuit judge, with 1 concurring. Ronnie Van Zant and Cleopatra Records. Sounds like Leonard Skinner. Phase 1 warning on provision of consent decree between city and homeless persons, requiring that after 1 warning, no person may obstruct a sidewalk in such a way as to endanger others by requiring them to walk on the street instead of an otherwise walkable sidewalk, did not require 1 contemporaneous warning. If drafters intended to require 1 warning per homeless police interaction, they would have done so expressly. Jeez. That's back to the city of Miami. So this is that case again. And that after warning, 1 person may obstruct a sidewalk, but could not require 1 contemporaneous. Wow, okay, that's going to be an interesting case, but I digress. Let's continue down here. And we're on to Section 186, the interpretation of consent judgment by appellate court. As with any other contract, interpretation of a consent decree is a question of law, and thus appellate court reviews the order de novo. Appellate courts recognize a variation of the standard rule of de novo review for consent decrees in instances where interpretation involves a fact-dependent legal standard or supervision of litigation, particularly in a public law context. Thus, while a trial court's views on the construction of consent judgments are entitled to deference, the interpretation of a consent judgment's provisions are a matter of law, subject to full review on appeal. However, there is authority that a court's review a trial court's construction of such an agreement as an issue of fact subject to the clearly erroneous standard. In such circumstances, a trial court may be better positioned to decide the issue in question, therefore warranting deferential review. Hopefully we don't have to get to that appellate court level by getting our judgments right to start with. And Section 187, presumptions as to consent judgment. A judgment by consent is entitled to the same presumptions as any other judgment rendered in the ordinary course of procedure. When made by consent, it is presumed that the trial court found acts necessary to support the consent judgment. The consent judgment has binding force from the presumed voluntary acquiescence of the parties, not merely from the adjudication by the trial court. Because a consent decree represents a settlement of the controversy by the parties, it is usually presumed that the parties intended to settle all aspects of the controversy, including all issues raised by the papers, compromising the record. Remember, we talked about the record before. These are instances, however, under which the parties reserve an issue or claim. So these are the instances. Remember, there's no rights reserved other than that. The contract would be determining factor there. Section 188, general operation and effect of consent judgment. A consent judgment is a conclusive adjudication with the same force and effect as any other judicially enforceable decree, such as one entered after trial, except to the extent that the consent excuses error and operates to end all controversy between the parties. Although there is some authority that a consent decree is accorded greater force than ordinary judgments, generally, the fact that a judgment is rendered by consent gives it neither less nor greater force or effect than it would have if it had been rendered after a protracted litigation, in the absence of fraud or mistake, or unconscionable advantage. A consent judgment with the approval of the court binds parties and their privies as fully as any other judgment. The agreement upon which a judgment is based may operate as an estoppel or waiver to end all controversy between the parties within the scope of the judgment. However, judgment entered pursuant to an offer of judgment, if silent regarding liability and the collateral estoppel effect of the judgment, has no issue preclusive effect and is not an admission of liability by the offeror. The failure of a party to perform under a consent judgment does not void the judgment. So they're still held to it just because they don't perform under a consent judgment. Same force as any other judgment. So we have here a cumulative supplement, the cases. Stipulated judgment entered pursuant to void settlement agreement would be merely avoidable, not void. Trial court could not declare judgment void absent allegations and proof that it had no subject matter or personal jurisdiction in the case, or that a party was not given notice or an opportunity to be heard as required by due process clause. Wow. So a stipulated judgment. Remember, we went over void and voidable judgments. Enter pursuant to a void settlement agreement. Pursuant to void settlement agreement. Let's see, are they using this as a verb? See, when they give you these cases in the cumulative supplement, they leave out articles and other parts of the grammar here. So let me read this one more time. Stipulated judgment entered pursuant to void a settlement agreement would be merely voidable, not void. Trial court could not declare the judgment void absent allegations and proof that it had no subject matter. Okay, so it needs to be heard. It needs to be ascertained, so it's voidable, not void on its face. Trial court's conclusion that a landowner was not compliant with consent decree between the landowner and town concerning land use violations, thereby triggering imposition of prospective penalties described in decree, was not supported by the competent evidence. Although town attached affidavits of its engineer and code enforcement officer to its motion to enforce decree, and rule concerning taking of testimony allowed trial court to hear matter on affidavits, where trial court did not hold hearing, did not inform parties it would decide motion on affidavits, and did not give landowner opportunity to submit affidavits in opposition to town's affidavits, and further, simply attaching documents to motion was not equivalent of properly introducing or admitting them as evidence. This is a really good case, 2020 in Maine. Town of Gorham versus Duquesne. This sounds familiar, this case. Oops. This is something that we should be aware of. Give me a second here. I just lost it again, didn't I? Come on, get back here. All right, there we go. We're back. Let's see. One more time here. Okay, here. There we go. All right, we're back. Zoom back in here. And let's get back to the chat and see what we got going there. See what section we're at here. 5, interpretation. And there we go. Appellates. And let's get over here to the chat. Appeals courts for losers. Yeah, I guess you could say that. Not in a bad context, but in general, indeed. That's when you lose. That's, I guess, the next course of action. All right. Let's get back over here to the presumptions as to consent judgment. I think that's where we left off. Yes, indeed. So where we have the presumptions as a consent judgment, presumptions, courts of presumptions. A judgment by consent is entitled to the same presumptions as any other judgment rendered in the ordinary course of procedure. When made by consent, it is presumed that the trial court found facts necessary to support the consent judgment. See, presumed. It didn't. It presumed. The consent judgment has binding force from the presumed voluntary acquiescence, of the parties, and not merely from adjudication by the trial court. Because a consent decree represents a settlement of the controversy by the parties, it is usually presumed that the parties intended to settle all aspects of the controversy, including all issues raised by the papers compromising the record. There are instances, however, under which parties reserve an issue or claim. That's footnote 5, section 173, which we already went over. Now on to section 188, general operation effect of consent judgment. We're almost done, guys. Stick with me here. A consent judgment is a conclusive adjudication with the same force and effect as any other judicially enforceable decree, such as one entered after trial, except to the extent that the consent excuses error and operates to end all controversy between the parties. Although there is some authority that a consent decree is accorded greater force than ordinary judgments generally, the fact that a judgment rendered by consent gives it neither less nor greater force or effect than it would have if it had been rendered after protracted litigation, the absence of fraud or mistake, or unconscionable advantage. A consent judgment with the approval of the court binds the parties and their privies as to any other judgment. The agreement upon which a judgment is based may operate as an estoppel or waiver. So we went over this part already. Although sometimes, they do repeat in here in different ways to get certain points through, so it can be sit off track here. So we did the general operation and effect of consent judgment, the finality. Consent decrees and consent judgments are entitled to a presumption of finality. Although there is some authority that consent decrees are not final, appealable orders, generally a consent decree is considered a final judicial order. An agreed order is accorded the same degree of finality and binding force as a final judgment rendered at the conclusion of an adversary proceeding. Where there is no language in the consent ordering reflecting it to be anything other than a final judgment, and the court does not leave for future adjudication any claims as between the parties, the consent order is final. Such decree is merely court's recordation of private agreement of parties. However, dismissal order pursuant to settlement agreement is final order, relief from which requires timely filing of a motion to vacate. Oh, wow. So there it is. And consent order expressly provided that injunctive relief sought by appellees was granted in its entirety and that all matters raised by appellant were dismissed with prejudice. And that was 1992 in Georgia. And we have section 190, the supervision of court over consent judgment. And let's jump over here to the chat and make sure I get this all refreshed. Okay, there we go. All right. Yes, Bill Thomas says, yes, not in a bad way. If you win an appeal, it's possible your name might become part of a case law. Indeed. Well, it would be referred to in case holdings. The legislature makes laws. So, the entry of a consent decree does not terminate a district court's jurisdiction. If a consent judgment does not have an expiration date written to its terms, it generally remains in effect until it is dissolved. Court jurisdiction over consent judgments is usually retained for an indefinite period. If a consent judgment has an expiration date, then, absent a breach of the terms of the consent judgment by the party seeking termination, court jurisdiction terminates on the expiration date written into its terms. Consent judgments are subject to continuing supervision and enforcement by the court. Because a consent judgment is a judicial act, the proper remedy is enforcement where one of the parties does not comply with its terms. The power of the court to enforce its judgment is no less and no greater for a court-adopted consent judgment than for a judgment resulting from a jury verdict in a contested adversary proceeding. The court stands behind the decree, ready to interpret and enforce its provisions. A penalty pursuant to a consent decree is subject to enforcement by appropriate process. Govern yourself accordingly. It's observation. There are several reasons relative to enforcement as to why parties may choose to settle their disputes by consent decree rather than by private contract. For instance, public law settlements are often complicated documents designed to be carried out over a period of years, so any purely out-of-court settlement would suffer the decisive handicap of not being subject to continuing oversight and interpretation by the court. It is easier to obtain enforcement of a consent decree because it will be unnecessary to prove many facts that would otherwise have to be shown in order to establish the validity of an ordinary contract. So you can agree to terms of a contract and have it enforced and not necessarily have the facts challenged later. A court that maintains continuing jurisdiction over a consent decree will have more flexible repertoire of enforcement measures. Also, it is likely to be easier to chain a litigation concerning the validity and implication of a consent decree into a single forum. The court that entered the decree, thus avoiding a waste of resources and the risk of inconsistent or conflicting obligations. Nice, and that's our observation there. So, we get down to there is authority to the effect that a prospective provisions of a consent decree operate as an injunction. This injunctive quality compels the court to 1. Retain jurisdiction over the decree during the term of its existence, which may be indefinite. 2. Protect the integrity of the decree with its contempt powers. And 3. Modify the decree should change circumstances, subvert its intended purpose. Whoa, so here's where a court can modify the decree. Compels the court to with injunctive qualities. Now that's interesting. That's footnote 10. Steele versus guardianship and conservatorship. Okay, well there you go. I know we had a question in chat and I knew it would be coming up. Yeah, so there's your case. You could look at that one if you needed more information on that, but that's one that applies here. So yes, indeed. That's the footnote 5 and footnote 10. And that's in Kansas, 1992. All right, interesting. And it takes us to section 191, the supervision of court over consent judgments, the termination of jurisdiction. So, the district court must determine whether and when to terminate supervision or jurisdiction over a consent decree by considering the specific terms of the consent decree. A party seeking dissolution of a consent decree must show that the decree has achieved its purpose and no longer serves the public interest. Several factors for the court to consider are 1. Any specific terms providing for continued supervision and jurisdiction over the consent decree. 2. The consent decree's underlying goals. That must be written well, though. 3. Whether there has been compliance with prior court orders. 4. whether defendants have made a good effort to comply. 5, the length of time the consent decree has been in effect if it's expiration. And 6, the continuing efficacy of the consent decree's enforcement. Court supervision is often expected to continue for several years in order to assure compliance with the relevant decrees. When the defendants are shown to be in compliance with its terms and objectives of the consent decree have been achieved, the court's jurisdiction over the case may be terminated. When it's shown, it's footnote 4, and these are all Heath versus DeCourcy, 1993. And supervision of court over consent judgment modification. Prospective relief under a consent decree is subject to continuing supervisory jurisdiction of the court, and the relief may therefore be altered according to the subsequent changes in the law. The appropriate remedy, when a significant change in facts or law warrants modification of a consent decree entered by a federal court, is a motion for equitable relief from judgment. The party seeking modification of a consent decree must establish that a significant change in facts or law warrants revision of the decree and that the proposed modification is suitably tailored to the changed circumstance. Suitably tailored to the changed circumstance. Great language here. When significant changes in factual conditions make a consent judgment unworkable, make compliance substantially more onerous, or make enforcement detrimental to the public interest, the court has the discretion to modify the judgment. However, changed factual circumstances in and of themselves are not sufficient grounds for relief from a judgment. Amendment of a consent decree in a long-standing case is fair, adequate, and reasonable, as well as legal. Wow, amendment in a long-standing case. So again, make sure those agreements are airtight for future potential of issues. Give me 1 second here. Wow, this thing really doesn't like to refresh chat, does it? Right. Okay, there we go. All right, so modification rather than termination of consent decrees controlling entry-level police officers and firefighters in cities was warranted, even though the decrees were over 40 years old, and there was no evidence of any lingering effects of unconstitutional examinations conducted when decrees were originally entered, where, due to demographic surges, strict ratio requirements in decrees had prevented some cities from reaching parity, and it was likely that consent decrees as modified would result in reaching goal of parity within a 5-year period. Boston, oh gosh. So yeah, that looks like a terrible decision in the first place, being further perverted all the way to 2018. And here we get footnote 5 is concerning the future employment of a former school principal who canceled a prom after learning that interracial couples planned to attend in 1995. Oh, Lord. And 193, Section 193, the effect of consent judgment on non-participating third parties. Although a consent decree has a binding force of a legal determination only on the parties to it, judgment by consent need not apply to all the parties to a cause. One party, whether an original party, a party that was joined later, or an intervener, cannot preclude other parties from settling their own disputes and thereby withdrawing from litigation. Thus, while an intervener is entitled to present evidence and have its objections heard at hearings on whether to approve a consent decree, it does not have power to block the decree merely by withholding its consent. Caution. According to some authority, there is an exception to the general rule that parties to a consent decree may not impose obligations on an unwilling third party. Under some circumstances, federal courts require that an innocent third party to participate in remedies for illegal discrimination. This exception permits third-party entitlements to be altered if a court finds that alteration is necessary to an appropriate remedy for a legal wrong. That's footnote 5. What is that? City of Chicago, U.S. versus City of Chicago, 92. I'm sure that was a stellar decision there. All right, there is there is authority that, unlike a simple settlement, a stipulation of the insured liability and signed by the insurer and later entered as a judgment constitutes a final judicial determination. Unlike a simple settlement, a stipulation of insured's liability signed by the insurer and later entered as a judgment. So that becomes a consent judgment, it seems. However, this holding applies in the case where the insurer both participated in the settlement and signed the stipulation, where the insurer had not received reasonable notice of the settlement, or was not allowed to control the insured's defense in the proceedings. The stipulated judgment would only be presumptive evidence of the insured's liability. Okay. So they're participants. So as judgments in the insurance context, we could have to go into AmJur insurance. And that's it. That takes us to the end of this. We've made it through consent and judgments. This has been one marathon, and I definitely appreciate everyone making it through. That's stuck through this whole way. A salute to you all. Yeah, Zach, appreciate you. And I guess, yeah, okay, I'll need to refresh this chat. So I need to do. There we go. Yes, this was a good one. And we definitely covered a lot. So we've really gone over a lot of nuances of judgments and the effects, the types, particular types, and really gone a deep dive into consent judgments, which is a particular kind of judgments that we're going to, I mean, once you know what this is now, you're going to realize that there are many, many situations where consent judgments have been applied. Again, this is to save time and money, and also to expand the powers of the court to go beyond where they might have jurisdiction. The consent decree or consent judgment would allow a judicial act to go beyond the scope of its powers normally in a particular matter, it seems. So there's a lot of different ways of interpreting consent judgments. I hope everyone got a better insight to it, if not just a general awareness of consent judgments and how they apply in the whole context of American jurisprudence. And with that, I salute you all for being here, and I hope to see you all on the next one. Peace out.